Hello, my name is Vinny Casiano, and I'm an elder law and estate planning attorney in San Diego. Rest assured you've reached the right attorney, as I've been practicing in the area of estates and trusts for over 20 years, and I've drafted literally thousands of estate plans, from the simplest to some very complicated plans for multi-million-dollar estates. What I'd like to talk about today is, how do you deal with a beneficiary that's disappointed because you didn't leave them as much as they thought they should receive? The first thing I tell most people is, do not procrastinate in getting an estate plan in place. Most frequent attacks on the validity of an estate plan are based on capacity and undue influence. With respect to undue influence, you have to understand that people are more easily unduly influenced the older they get, as the more likely it is that they will begin to experience some sort of cognitive decline. And believe it or not, more than 70 people die without having an estate plan in place. Why? Because they procrastinate and never get around to it. The next, which is probably just as important, if you're going to do a plan, don't do it yourself. Retain an experienced elder law and estate planning attorney to help you design and draft your documents. Whatever you do, don't try to do it yourself, because more than likely, you're not going to do it right. The value of utilizing an experienced attorney is that they'll be able to advise you on the best way to achieve your objectives. If you try to do it yourself, you don't even know if what you've designed is going to be legal or whether it will stand up in court. Every year, thousands of do-it-yourself estate plans, including wills and trusts, are challenged because of inconsistencies, ambiguities, missing language, or they don't just sign them the right way at the end. These are people that are trying to save a little bit of money by using LegalZoom or Rocket Lawyer or something like that. The value that I offer my clients is that I work with them every step of the way to make sure we get it right. The next thing I think is very important is, you have to avoid the appearance of undue influence. It is really common for me to be contacted by adult children who are trying to make sure that their parents' plans are in place and that they're up to date. And the parents have even said to the children, hey, call an attorney. Can you set this up for me? What I have to explain right away is, hold it, let's take a step back here. I want to make sure that whatever the parents want, the person that I'm working with, whoever my client is, that those objectives are going to be followed. And the easiest way for that to be challenged is on undue influence, right? Undue influence means that a beneficiary has pressured or persuaded their parent to the extent that their independent decision-making has been overpowered. So it's not really their decisions. As a result, if you left a gift to a beneficiary and it's determined that they unduly influenced you, well, that gift is going to go away, right? If your estate plan favors somebody that you allowed to be at those meetings and take part in the consultations with the attorney, that is the simplest way to have that plan thrown out. Understand that I have a unique perspective on this, because not only do I draft plans, but I litigate them as well. So one of the first questions I'll ask the drafting attorney in a deposition is, who did you speak to? Who was at the meetings? And if that child that was favored was there and the child that was not favored was not, that's pretty easy for a judge to come up with the fact that that parent was probably unduly influenced. So you want to avoid that. One of the other things you might want to consider, this isn't always right, is disclosing the contents of your plan to your family. So if you have somebody that you're leaving less to, you may want to let them know. I think this is a little different than if you're totally disinheriting a child because that child is a problem child and they've just caused you problems in the past. But if it's a child that you're leaving a little less to, or maybe a lot less to, because maybe they've done very well, or you believe that another child really needs more, you might want to disclose that to the entire family so everybody's aware of your wishes. That way, they're not finding out after you've passed and then want to fight the plan. So the bottom line here is, you want to make sure that you retain the services of an experienced elder law and estate planning attorney that has experience in not only drafting these plans, but litigating them as well so they can best advise you on how to design a plan that will minimize the likelihood of somebody who does contest it ever succeeding. Please give me a call or text me at 619-800-6820, as I'm more than happy to talk to you about how I can help.